Joint tenancy versus tenancy in common, which protects your NY property. When two or more people co-own real estate in New York, the words on the deed can mean the difference between a smooth transfer and a lengthy, costly probate battle. Joint tenancy and tenancy in common are the two primary ways unmarried co-owners hold property in New York, and each carries profoundly different legal consequences for inheritance, creditor exposure, and ownership rights. In a joint tenancy, the right of survivorship means that when one owner dies, the surviving co-owners automatically inherit that share without going through probate. Tenancy in common works differently because each owner holds a distinct, transferable share that passes through their will or under New York's intestacy laws when they die. Under New York Estates Powers and Trusts Law, Section 6, 2.2, any deed transferring property to two or more non-spouse co-owners is automatically treated as a tenancy in common unless the deed expressly declares a joint tenancy. Joint tenancy in New York requires the four legal unities to exist simultaneously: unity of time, unity of title, unity of interest, and unity of possession, meaning all owners must acquire equal shares through the same instrument at the same moment. If even one joint tenant transfers or severs their interest, that portion converts to a tenancy in common, though the remaining joint tenants may still hold their interests in joint tenancy among themselves. Tenancy in common offers greater flexibility, allowing one owner to hold 70% while another holds 30%, and each owner may sell, gift, mortgage, or devise their undivided share without the other owner's consent, subject to any co-ownership agreement. Creditor exposure follows the ownership structure as well, since a creditor can reach a debtor-owner's interest under either form, but enforcement activity against a joint tenant's share can sever the joint tenancy entirely. Choosing the wrong ownership structure at the outset can trigger unexpected probate proceedings, inheritance disputes, or estate planning complications that are far more expensive to untangle than to avoid. Manhattan real estate attorney Peter Zinkovetsky helps buyers, sellers, and co-owners prepare and review deeds, resolve title issues, and address co-ownership concerns before they become legal disputes. Whether you are purchasing property with a family member, investment partner, or any other co-owner, a carefully drafted deed reviewed by a knowledgeable lawyer can protect your interest from the moment you take title. The law firm Avenue Law Firm represents both local and international clients navigating New York real estate co-ownership, providing guidance that is grounded in the specific language and requirements of New York property law. When the survivorship question matters most, having an attorney review your deed before you sign ensures that the ownership structure you intend is the one the law actually recognizes. Contact Avenue Law Firm at 212 729 4090. Located at 505 Park Avenue #1201, New York, New York 10022, United States, to schedule your consultation and make sure your deed says exactly what you need it to say.